Start. In reversing the order of acquittal and passing the impugned order, the High Court first reappraised the evidence in the light of the above findings and demonstrated that each of them was perverse, it then considered the evidence of the three eyewitnesses to ascertain whether it could be safely relied upon to base a conviction, On such consideration, the High Court found that PWs 1 and 2 were the most probable and natural witnesses and that their evidence was credit-worthy, The High Court, however, left the evidence of PW3 out of consideration as he was not an independent witness, The High Court further found that the evidence of PW1 stood fully corroborated by the FIR, which was lodged within half an hour of the incident and that the evidence of both PWs 1 and 2 stood corroborated by the medical evidence, This being a statutory appeal, we have carefully perused the evidence adduced by the prosecution, particularly that of PWs 1 and 2, keeping in view the judgments of the learned courts below, and we are constrained to say that none of the grounds canvassed by the trial court to acquit the appellants, can be sustained, The contradictions, which persuaded the trial court to disbelieve the eyewitnesses related to their omissions to make certain statements before the investigating officer, which they made before the court, On perusal thereof, we find that the omissions were so minor and insignificant that they did not amount to contradictions at all, As regards the comment of the trial court that the prosecution made no attempt to dispel the anomaly about the place where the deceased was attacked and his dead body was found, we are in complete agreement with the observations of the High Court that the above comment was the outcome of non-consideration of the evidence, According to the evidence of PW6, the dead body of deceased was found lying near the Pagdandi, The evidence of the prosecution witnesses thus clearly proves that deceased met with his death at the place where his dead body was lying, The finding of the trial court in this regard must, therefore, be said to be perverse, In our opinion, neither the criticism of the trial court nor the reason ascribed by the High Court in its rebuttal can be legally sustained, While preparing a site plan, the investigating officer can certainly record what he sees and observes that it will be direct and substantive evidence being based on his personal knowledge, but as he was not obviously present when the incident took place, he has to derive knowledge as to when, where and how it happened, When a witness testifies about what he heard from somebody else, it is ordinarily not admissible in evidence being hearsay. But if the person for whom he heard is examined to give direct evidence within the meaning of Section 60 of the Evidence Act, the former's evidence would be admissible to corroborate the latter in accordance with law, para. However, such a statement made to a police officer, when he is investigating into an offence in accordance with Chapter 12 of the Code of Criminal Procedure cannot be used to even corroborate the maker thereof in view of the embargo in section 162 in bracket 1 CRPC appearing in that chapter, and can be used only to contradict him in accordance with the proviso thereof, except in those cases where subsection in bracket 2 of the section appeals full stop. That necessarily means that if in the site plan, comma, PW6 had even shown the place from which the shots were allegedly fired after ascertaining the same from the eyewitnesses, it could not have been admitted in evidence being hit by section 162 CRPC full stop. It would be extremely improbable for the injury which was received by the deceased to have been caused on that part of body where it had been actually caused if the deceased was at the place marked on the map full stop.